Hello, I'm attorney Vince Davis. Today, we are going to take a deep dive into one of the most complex areas of California criminal law, DUI offenses. A DUI arrest in California initiates a dual-track legal process involving both the criminal courts and the DMV, functioning independently of one another. First is the DMV administrative per se hearing. You have exactly 10 calendar days from your arrest to request this hearing to save your license. If you fail to request this hearing within that 10-day window, your driving privilege will be automatically suspended, usually starting 30 days after the arrest. The burden of proof at a DMV hearing is a preponderance of the evidence, a much lower bar than the criminal court's beyond a reasonable doubt standard. Second is the criminal court case. This determines guilt or innocence, where the prosecution must prove their case beyond a reasonable doubt. Under Vehicle Code Section A, it is illegal to drive when your physical or mental abilities are impaired by alcohol or drugs, regardless of your BAC. Section B is the per se DUI. This makes it illegal to drive with a blood alcohol concentration of 0.08% or higher, even without apparent impairment. For a first offense, you are looking at up to 6 months in jail, thousands in fines, and a 6-month license suspension plus mandatory DUI school. A second offense carries mandatory jail time and a 2-year suspension. By the third, jail minimums jump to 120 days with a 3-year revocation. California uses a 10-year look-back period, meaning prior convictions within that decade will significantly increase the severity and penalties of a current charge. When you factor in penalty assessments and court fees, the financial burden of even a first-time DUI can easily exceed $4,000. Refusing a chemical test leads to an automatic 1-year suspension under implied consent laws, and you are generally not eligible for a restricted license. Aggravating factors like a high BAC over 0.15% trigger much harsher sentencing and longer mandatory DUI school requirements for offenders. Having a minor under 14 in the car triggers a mandatory 48-hour jail enhancement and potential child endangerment charges on top of the DUI. DUI causing injury is the most severe, often prosecuted as a felony carrying a state prison sentence of 16 months up to 3 years. While the penalties are daunting, it is important to remember that being arrested is not the same as being convicted. There are many valid legal defenses available. One common defense is rising blood alcohol. This argues that your BAC was actually below the limit while driving, but rose by the time you were tested. We also look for Title 17 violations. Any deviation from strict lab procedures, like failing the 15-minute observation, can render test results inadmissible. If the officer lacked reasonable suspicion for the traffic stop, all evidence gathered, including chemical tests, may be suppressed as a violation of your constitutional rights. In some cases, we can negotiate a wet reckless plea bargain. This is a reckless driving charge involving alcohol, which carries lighter penalties than a standard DUI. Factors like acid reflux or recent use of mouthwash can trap alcohol in the mouth, causing a breathalyzer to give a falsely high reading during the test. Field sobriety tests are also highly subjective. Factors like fatigue, uneven pavement, or even poor footwear can lead to inaccurate officer observations and reports. California is increasingly moving toward universal mandates for ignition interlock devices, even for first-time offenders, as a requirement to regain driving privileges. If you drive for hire, like for Uber or Lyft, your legal limit is much lower, just 0.04%, the same as commercial truck drivers in California. Navigating these two parallel legal systems requires an experienced attorney who understands how to fight both the DMV and the criminal court systems. When we meet, we will go over the specific facts of your arrest and develop a tailored strategy for your defense in both the administrative and criminal tracks. Remember, the decisions you make immediately following an arrest will shape the outcome of your case. Don't wait to seek professional legal help for your future. If you or a loved one are facing a DUI charge in California, reach out to us right away to begin building your defense and protecting your future. Call us at 888-888-6582. We are here to help you through this difficult time.